When does the power of attorney start being effective? There's the legal answer and the practical answer here. I usually make them effective when they're signed. You have a different approach that, okay, well, I only want the power of attorney to be effective if I'm incapacitated. But now, so let's say I appoint Bailey as my agent, and I say it's only effective when I'm incapacitated. So she goes to the bank, and the bank says, well, is he incapacitated or not? So now she has to prove to the bank that I'm incapacitated. And she can say, well, just look at the video that he gave. He's obviously incapacitated. But, you know, if you make it dependent on a specific event, then the agent has to prove that that event happened all the time, and that can be problematic. So I usually make them effective as soon as they're signed. Now then, the practical thing is, really they're effective when you give it to the agent. So one method is you keep it with the law firm, and then there's an agreement that if the agent shows up, the law firm will give the document to the agent so the agent can start using it. But the law firm won't give the document out if the law firm suspects that there's something not quite right. Now, that's not a perfect system, but you know, it gives the law firm the ability to say, okay, if there's something that doesn't look right, we'll investigate and see if it's really a situation where we want to confer that person. Now, if you have given the document out to the agent and you have a change of mind and you want to revoke the document, you know, you can sign a new power of attorney and say, I revoke the former power of attorney. But of course, if the old agent has the document, then the old agent can present that to a bank, and if the bank doesn't know any better, they're going to assume it's a valid document. So if you're revoking a power of attorney, you got to get all the originals back, or you have to go to everybody who that person is likely to deal with and say, okay, I've changed it, and this person is no longer my agent. So its possession is 9/10 of the law, that general saying. So once you give out the document to the agent can use it.
Well, unless you do, so that's if you make the document effective when it's signed, and you give a copy of that document to your agent, that's it. They can use it. So that's why Blair's saying that what he likes to do is have it effective when signed, which is what it'll say right on the document. This document is effective as of the date that it is signed, or as of date, and they fill in the blank and then they sign it on that time. So, or you can do what's called a springing power. So as you see up there, it kicks in when there's a specific event. It springs from that event, and that's what Blair was saying. For example, when I'm incapacitated, or for example, my example, when I'm traveling, it kicks in when I'm out of the country, or whatever. Again, there's flexibility, so it's whatever defined event you want it to be. There's a protection there with the fact that now your agent can't just go and use it right away, but it comes at a cost, as Blair was saying, which is the fact that they then have to prove that that event happened.
Yeah.
So that might be quite inconvenient for them. So these are things you need to balance out when you're thinking about how you want, again, flexibility, how you want your plan to work for you. And yeah, I think that was it on that point.
And then the final point is the power of attorney stops once you stop. When on death, the power of attorney is no longer effective. Power of attorney, there are two types, simple and enduring. Now, when I went to law school, I didn't know what a power of attorney was, and this caused me no end of confusion, because I thought, okay, simple power of attorney, I have a pretty simple life, so that must be what I need. But an enduring power of attorney sounds nice too, so that must be printed on acid-free paper and hardcover. And I couldn't figure out why people with simple powers of attorney don't get the nice cover on it. So then I went to law school and found out that those terms don't mean, legal terms are often misleading, I find. So a simple power of attorney simply means that it goes back to agency law. And so much of legal stuff is buried in the past. Agency law was, once you cease having capacity. Once you lose capacity, any agency relationships terminate because you can no longer fire the agent because you don't have capacity, because you can't supervise the agent. So that at general law, whenever you appointed an agent, if you weren't able to supervise that agent, the agency terminated. Now, of course, if you're appointing somebody to take care of you when you no longer have capacity, that doesn't work. So they brought in the Power of Attorney Act and created the enduring power of attorney, which endures past your incapacity. So even though I'm not able to supervise the agent anymore, the agency continues, and that's what you need the power of attorney for. So most powers of attorney are enduring, but the limited power of attorney for the house sale can be simple. I just need it for that specific purpose. It's a finite period of time. And that's why, again, you need somebody you trust implicitly, because if you lose capacity and you're not able to supervise that person, you're in a vulnerable position, so you need somebody you trust who's going to have your back. The wording. There's
Yes.
magic wording.
Magic wording if you want to have an enduring power of attorney, which also, just in terms of jargon, another word for that is a general power of attorney, which I used that word earlier. So there's simple and there's general / enduring. So general and enduring are the same thing. And it needs to have this legal phrase in it, stating that the power of attorney will carry on during any subsequent mental infirmity. So if you were to do the do-it-yourself approach, you would see that that's an option on templates online. It'll have this wording. So you just need to make sure if that's the wording that you want, or from your lawyer or from your notary, that this wording is in there.
Yeah.
And the other thing about enduring power of attorneys is that they need to be signed formally. So you need to have a lawyer present or a notary present when you sign them, because when you think about it, they're a lot bigger of a deal. You're giving a lot more power to someone than with a simple. So you need to do it with in a formal way before someone.
Yeah, and I think at recent amendments to the Power of Attorney Act, you can actually sign it in front of 2 witnesses now. But I think it's safer if you sign it in front of a lawyer, and then the lawyer can say, yes, we explained that this was an enduring power of attorney and the consequences of that. Now, if you do lose capacity, the agent has fiduciary obligations. That's a jargon term, but it basically means that the agent's primary responsibility is to take care of you. And everything that the agent does has to be for your benefit. Now, this can be an issue, and on a one-page power of attorney, it's usually not addressed, because you might want the agent to also take care of your children and use some of your assets for the benefit of your children. But you have to expressly say that, because by law, if you don't have capacity, the agent has to take care of you. You aren't your children. So you need an express power in the document to, also use my benefit for my family, my assets for my family. If you're somebody who gives to charity, the agent cannot give gifts to anybody unless it's expressly, or he's very limited to a very small gift. So if you're somebody who donates to charity, you might want to put in a specific power that person can give gifts to charity as long as they're reasonable, but they're not subject to the statutory limit of a certain percentage of your taxable income from the previous year. Like to put in express powers to do tax planning, because a lot of tax planning, as we'll get into later, involves things for the benefit of your children, for the next generation, not necessarily for your benefit. So the agent has to act only for your benefit at common law. So you might want to put in a few express powers to do other things that aren't quite for your benefit. This is just an example of a basic, simple power of attorney. The ones that you get in stationery stores are one page, and they leave a lot out. But that gives you an idea.
Sorry, just to clarify, this is not a simple. This is a general or enduring.
Yeah.
So it's simple in the sense that it's a template, but it's not a simple power of attorney. As you can see, got that second to last bullet, it's to be exercised during any subsequent mental infirmity on my part. So this is a general enduring power of attorney.
Yeah, and it's just an example. And it's not, it's just an example, so you can put in whatever you want as a way of extra clauses. And our powers of attorney tend to be about 12 or 13 pages long, just because we want to put in a list of this is what the agent can do. And if you're not comfortable with any of those things, then we can put in a provision saying the agent can't do this. But again, if you're not comfortable with the agent doing something, that probably means you're picking the wrong person, because you need to be comfortable with the person you picked. Okay, representation agreements. These are alternatives to the power of attorney. Remember, I said there were two different philosophies. So I'm in charge of my own, I can make my own plan. The second approach is, well, maybe I don't have the mental capacity to set up a power of attorney. What then? Then we have the representation agreement. And there are two types. There is the one where the donor has full capacity and could set up a power of attorney. Now, usually in that situation, we go with the power of attorney just because it's a term that people are familiar with, and it has more of a chance of being recognized outside British Columbia because Manitoba has powers of attorney. Now, having said that, if you do own property in another province, you should probably get a power of attorney signed in that other province, because property and civil rights in Canada is a provincial responsibility. So if I own real estate in Manitoba and I try to sell it with a BC power of attorney, there's a risk that somebody say, well, this is a BC document. You should have a Manitoba power of attorney. That's because you want people to recognize it, and somebody in Manitoba is going to have an easier time recognizing a Manitoba power of attorney. So if you own property in another jurisdiction, have a BC power of attorney, have a power of attorney in that other jurisdiction. And they can be the same document, but sometimes they have slightly different signing formalities. In BC, if you're dealing with real estate, you have to have a specific clause in the power of attorney that the power of attorney extends beyond 3 years. Otherwise, the Land Title Office won't recognize the power of attorney. And if if you signed your power of attorney in Manitoba, there's no reason it's going to have this BC clause. So it's important to have a power of attorney in each jurisdiction where you own assets.
Just real assets?
Well, any assets where you want somebody to recognize the authority granted by the power of attorney. So real estate is one, because real estate law tends to be idiosyncratic. But if you have a bank account in Manitoba and you want somebody to be able to deal with it, I would put a Manitoba document in. And it can be the same document, but it's just governed by Manitoba law, and the person who needs to recognize the authority of the agent is going to be able to do it much more easily. Okay? So if the donor, I guess you give a power of attorney or you give authority to somebody, so we talk about a donor, has limited mental capacity, they're in that gray area. Do they have capacity or don't they have capacity? That's where we use the representation agreement. And we tend to use power of attorney where it's clear the person has capacity, representation agreement for these other situations. Now, we'll deal with the representation agreement when we deal with healthcare matters more, but it can also be used for financial stuff.